Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, earlier this week, rumors started igniting the Twittersphere that the Glock handgun company would be discontinuing most of its models and replacing them with the new V series. What's the V series? Well, apparently those are models that cannot be manipulated or altered through the use of an illegal Glock switch. Now, it has many people in the 2A community wondering, what does this mean for the new models? What does it mean for the old models? Is Glock's reliability still going to be there? And other aspects related to that firearm. We're not going to talk about any of that. Instead, what we're going to talk about today is, what do the new Glock models mean legally? Okay, America, we're going to be talking about the rumors that have now been confirmed that the Glock handgun company will be discontinuing several of their models and replacing it with the new V series, a firearm which cannot be manipulated or altered by the Glock switch. Now, the information that I'm relying on comes from an article that I read on USA Carry. It's linked down below, a reputable publication that has confirmed through Glock that these rumors are all true, that most of their previous models are about to be discontinued. In fact, no longer will be shipped to gun stores, and most of those models, the ones that are being discontinued, will be replaced with a new V series. The only models that Glock is not discontinuing at the current time is the Glock 43, the Glock 43X, and the Glock 48. Beyond that, all other models, and as you can see from this list right here, again, pulled from the story on USA Carry, virtually every other model will now come in the new V series. These new models will start shipping around the 1st of November. Now, we could sit here and talk about all kinds of cool aspects with the firearm. What does this mean? What does the redesign mean? What's the trigger going to be like? Are they going to have the same reliability? We could talk about, what do I do with my Gen 3, my Gen 4, my Gen 5, any of that stuff. But we're not going to talk about any of that. Why? Well, that'd be getting a little bit out of our lane here, wouldn't it? So we'll just let Mr. Guns and Gear talk about all of that stuff. But what we are going to talk about is, what is the legal effects of Glock choosing to discontinue most of these models and replace them with a model that cannot be manipulated by the Glock switch. And what we have to look at is two significant legal issues right now that is facing Glock. The first, of course, is California Assembly Bill 1127, the ban on selling Glock handguns. What does this change in model mean to that law moving forward? The other thing we have to talk about is there are currently, at least to the best of our knowledge, 3 lawsuits pending against the Glock handgun company, one in New Jersey, one in Chicago, one in Seattle. Those are based upon the fact that the plaintiffs are alleging that Glock knowingly engaged in behavior that created public nuisances, knowing that their firearms can be manipulated by Glock switches, and didn't do anything about it. Okay, let's go ahead and talk about Assembly Bill 1127, the California Glock ban. Will the redesign address this issue? In all likelihood, it will address this exact issue. Why is that? Well, because the folks in the California State Legislature actually provided a roadmap for a type of firearm that would not be subject to this type of ban. And yes, with design changes, Glock would absolutely positively be able to redesign their firearms. Section 3 of Assembly Bill 1127 reads as follows. As used in this part, machine gun convertible pistol means any semi-automatic pistol with a cruciform trigger bar that can be readily converted by hand or with common household tools into a machine gun by the installation or attachment of a pistol converter as a replacement for the slide's backplate without any additional engineering, machining, or modifications of the pistol's trigger mechanism. The same section of the bill also tells us a machine gun convertible pistol does not include a hammer-fired semi-automatic pistol or a striker-fired semi-automatic pistol lacking a cruciform trigger bar, which instead has a trigger bar that is shielded from interference by a pistol converter. And if that's not clear enough, what redesigns need to be made to bring this into compliance with this law, which could easily be passed in many of these other states right here? Assembly Bill 1127 also provides a polymer notch or other piece of polymer molded into the rear of the pistol frame does not prevent ready conversion into a machine gun and will not prevent a pistol from qualifying under this section. Well, what does this all mean? Listen, the folks at Glock have created an immensely successful company, and they have done so because they're not stupid, okay? They're good business people. And so knowing that crazy laws start in California and then spread like a vicious cancer around the country, and knowing that the California state legislature basically put in there what needs to be done to bring any of Glock handguns into compliance, yeah, these right here listed in Assembly Bill 1127 are the exact types of design changes you're going to see in the V series. So what does it mean? Well, it means that Assembly Bill 1127 is not going to have a huge impact on the ability for those that want to purchase Glock handguns, and any other state who's thinking about passing similar legislation understand that these firearms are being discontinued. Now, there are millions and millions of them that are in circulation, and they will remain in circulation because, again, Glock has established itself as building a very reliable and durable firearm. But moving forward, so long as you don't have some other crazy civilian disarmament ban, should you be able to purchase the new editions of Glock handguns? Yes, you should. Okay, then we got to talk about the Glock lawsuits. And we got one in New Jersey, we got one in Chicago, and we got one in Seattle. And many of you are thinking, oh my God, this probably hurts the lawsuits, right? Because, well, Glock knew they had a problem and they went out and they redesigned it. And now that evidence of the redesign is going to be used by the plaintiffs to prove, aha, they knew there was something wrong. They didn't do anything about it until we started suing them, and then they finally did something about it. It would make a really, really good argument, a potentially plausible argument, if it weren't for Federal Rule of Evidence 407. This is where I actually get to use my experience as a trial lawyer. Federal Rule 407, and understand that every single state is going to have a relatively similar rule of evidence in their state rules of evidence, is known as subsequent remedial measures. What that rule says is the following. When measures are taken that would have made an earlier injury or harm less likely to occur, evidence of the subsequent measures is not admissible to prove negligence, culpable conduct, a defect in a product or its design, or a need for a warning or instruction. So put in simple terms, it means that this evidence of the redesign and the V series is not admissible if these cases go to trial. Why do we have that rule? Well, it's based on public policy. In a general sense, if you have a product manufacturer who has perhaps created a potentially defective product and they respond to consumer concerns and they fix the potential defects, they are doing exactly what we want a responsible manufacturer to do. And those actions are actually furthering public safety. We don't want to discourage companies from doing that, because if they do it, all of a sudden, oh, well, they're going to use that as evidence against us. So that is the exact reason why we have Evidence Rule 407 and why every single state in the country has adopted a similar rule. So does it end the lawsuits? No, it doesn't end these lawsuits. These lawsuits will still continue. But did Glock weaken themselves from a litigation standpoint by taking these remedial actions, if they are remedial actions at all? Or maybe this is just a redesign for other purposes? That will have to come directly from Glock. The answer is no, they did not weaken their position in any way, shape, or form. So what are they going to look like? How are they going to operate? What's going to be different about them? I don't know, and there will be plenty of content creators who will share that information with you. But legally speaking, if we just focus on the application of the law to this design, what we'll find is that this redesign significantly minimizes the impact of Assembly Bill 1127 on the sale of Glocks in the state of California, and does not in any way weaken Glock's position in any of these three frivolous lawsuits currently being litigated. Okay, like I said, the article we relied upon comes from USA Carry, so we're going to link them up down below so you can check the article out. Don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, the link to do that's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.